Good morning, everyone. Good morning, Deshpande sir, Dr. Prasann. So we are here with our medical legal update IC, current scenario for ophthalmologist. I am Dr. Viral Shah from NIAC Hospital, Nagpur. So as we all know, these are very turbulent times for ophthalmic practice. Eye care centers being told left and right to pay compensation to patients for their vision loss, and such headlines you will see daily in your newspapers or social media posts. So we designed this medical legal update with myself, Dr. Viral Shah, as chief instructor, our mentor, Dr. Anand Deshpande sir from Aurangabad, Chhatrapati Sambhajinagar, Professor Dr. Rajesh Joshi from Nagpur, Dr. Hari Krishnan, Major Dr. Hari Krishnan from Hyderabad, and Dr. Prasanna V. Ramesh from Trichy. So unfortunately, Dr. Hari Krishnan cannot join us because of some family emergency. He has to leave for Kerala. So for this IC, I will be speaking on the new Bharatiya Nyaya Sahita, important highlights for ophthalmologists. Dr. Marathe was supposed to speak for CPA 2019. Dr. Deshpande sir will speak about dealing with legal notices, be practical and prepared. Dr. Rajesh Joshi will speak about medical records, most important evidence in court of law. Dr. Prasanna V. Ramesh, he will speak on medical legal aspects of teleophthalmology, and professional indemnity insurance was supposed to be covered by Dr. Hari Krishnan. So without wasting much time, I will start with my first presentation. Next presentation regarding Dr. Viral Shah, BNS. वहीं पे next presentation. Ready. So thank you at the outset to APO, AIOS, Scientific Committee of AIOS, for giving us this opportunity to conduct this IC. Bharatiya Nyaya Sahita 2023 is now in force. So what are the important highlights for ophthalmologists I will be covering? Myself is Dr. Viral Shah from NIAC Hospital, Nagpur. So such advertisements by IMA was there on 22nd of December 23 in all leading newspapers, in which the ads extended its gratitude to Prime Minister and the Union Home Minister for exempting medical professionals from the criminal prosecution for causing death due to rash and negligent act. But in reality, the new provision has not granted any immunity to the doctors from criminal liability. Rather, they have become more serious and dangerous for the doctors, and I don't understand what was the hurry by the IMA leaders to give such an ad without reading the actual document. Section 106 of the BNS, their provisions are applicable to medical practitioners who possesses any medical qualification recognized under NMC Act 2019 and whose name has been registered in the National Medical Register or State Medical Register under the Act. This means these provisions are applicable to all the MBBS doctors. Section 1061 of BNS, it deals with causing death by negligence. In the old Act, the Indian Penal Code corresponding was 304A IPC. So what has changed in 1061 BNS as compared to 304A of IPC? So there has got two parts or two limbs. The first limb deals with any person excluding the MBBS doctor. That means Ayurvedic practitioner, Unani, homeopathy, whatever, or some quacks. So if they cause any death to any person by doing rash or negligent act, not amounting to culpable homicide, then the said Ayush doctor shall be punished with imprisonment of either 5 years and shall also be liable to fine. So here they have replaced or imprisonment or fine with imprisonment and fine. Thus, as per this new act, both jail sentences and fines are mandatory for Ayush doctors also. The second limb of this section deals specifically with MBBS registered practitioners. If MBBS registered medical practitioner while performing medical procedure causes death of any person, then imprisonment of 2 years and fine. So for MBBS doctor registered for 2 years and fine, and for other practitioners except MBBS, it will be 5 years and fine. So even MBBS doctors are covered, and this now mandates jail sentence as well as fine, both. Previously, judge had the power to give some fine and let the prison sentence be suspended. But now, as per the wording, we don't know whether they have the powers right now. So first, this judgment is yet to come. Whenever the first judgment comes under this section, we will know how the judiciary interprets it. Thus, the new act is more dangerous to the doctors, and specifically it is more dangerous to the IOS doctors. If the doctor is convicted by the court under section 1061 of it, then a jail is mandatory. Punishment for doctors for not treating the patient. FIR to be filed against doctors under section 200 of Bharatiya Nyaya Sanhita. So there were such posts on the WhatsApp and various social media where the caption had created fear amongst doctor. This was nothing but mindless sensationalism by media, where it was said, now treating a patient, if we don't treat a patient, concerned doctor will be punished with 1 year jail or fine. Same provisions were there in the previous IPC under section 166B of the IPC, and there is no major change between 200 BNS and 166 of IPC. Specifically, the cases of acid attack victims, victims of rape, including gang rape, and child victims of sexual assault and penetrative sexual assault. These cases have to be treated by any practitioner, including ophthalmologist, if they come to your OPD. You may not have much resources to treat them, but just give them some first aid and refer them to the nearest government hospital or tertiary care hospital, and you have to inform the police that such and such a case has reported to your hospital, and please take note. So these two steps, if you do, you don't come under section 200 of BNS. Thus, the caption was highly misleading, and it was wrong and had no legal validity. So just follow these two steps. Document the patient had come to your OPD and you have given some primary treatment, and keep proof of police information and receipt from the police department acknowledgement. When can the FIR be filed against a doctor under section 1061 of BNS for causing death of the patient? And also, is it false to file a false FIR against doctor? FIRs are filed against doctor under section 1061 of BNS, but here we must understand whether that FIR will be tenable, does filing false charges of offence by police constitute an offence, and what are the views of SC about it. In spite of Supreme Court's many observations, FIRs are routinely filed by police without application of mind, and trials are framed by the courts under section 1061 of BNS, even when there is no evidence to point out the existence of intention or knowledge required. Therefore, doctor has to approach multiple courts to quash the FIR or charge sheet. Various landmark judgments are there regarding this, and appropriate section has to be applied. Section 240 of BNS, filing a wrong or misleading or prejudicial FIR against a doctor shall be punished with imprisonment up to 2 years. So expectation from the police official not to file FIR against doctors under section 106 if prima facie there is no evidence and it fulfills the major ingredients of the said section. So what has now become the rule for filing FIR under BNS? So as proposed by Bharatiya Nyaya Sanhita 2023, some key aspects are FIR is now mandatory. You have to file an FIR. It can be filed digitally. There is a timeline, specific timeline given for investigation, and there are stringent punishments for perjury and false FIRs. This proposed changes reflect a move towards modernizing India's criminal justice system by increasing transparency, reducing delays, and leveraging technology for more efficient processes. Key provisions related to medical practitioners. The punishment for causing death by rash or negligent has been increased to 5 years for non-registered medical practitioners and 2 years for registered medical practitioners. However, for medical practitioners, grievous hurt, the definition and duration of grievous hurt has been modified. Previously, it was 3 weeks, now it has become 2 weeks, 15 days, because of advancement in medical treatments. Now they are the opinion that patient can get treated faster with latest armatory available with the doctor. Legal safeguards has been given to doctors. Medical practitioners are generally protected from frivolous claims. Though the need for expert medical opinion to establish negligence, the BNS does not specifically alter the requirement for expert testimony, but continues to rely on established legal and medical standards for determining the malpractice. Expert opinion is crucial and a must while wherever a medical negligence case is filed. Courts often rely on testimonies from medical professionals to understand the standard of care and whether it was breached. Judicial consideration, courts consider the complexity and the risk inherent in the medical procedures, the practitioner's intent, and adherence to established medical protocols. So, various scenarios where the FIRs can be filed under doctors for medical negligence, death or harm. It is similar to one IPC 304A. Fraud or cheating, medical bills, false certificates under IPC 420. Sexual harassment or assault by doctor, illegal medical practices and unlicensed procedures, forgery and falsification of medical records, organ transplantation and drug violations, endangering human life or personal safety, drug violations, and criminal breach of trust, misuse of patient's fund. So this is all about the new Bharatiya Nyaya Sanhita which has come and how it is going to impact us in the future. And as time passes, we will know as more and more cases are filed and it becomes in the public domain, we will know more how this BNS is taking shape. Thank you. Thank you, sir.